Hi, my name is Daxton, and I'm a student at the Indigenous Community Legal Clinic, the ICLC, in downtown Vancouver. This video has been recorded on the unceded ancestral territory of the Musqueam, Tsleil-Waututh, and Stolo Nations. This video is part of the Lived Law series on end-of-life legalities and will cover Indigenous class actions and death. Many of our clients at the ICLC are involved in Indigenous class actions. This could be the 60 scoop claims that were due in 2019, Indian Day School claims that are due on July 13, 2022, or other potential future class actions, such as the one covering students excluded from the current day schools claim. For many of our clients, they run into further issues when the relatives who are eligible for these class actions have passed away. This video will look at how to prepare for such a situation if you are nearing death, and how to make a claim or access a payment for someone who is deceased. If you are eligible for the day schools class action and will not be able to complete a claim before you pass away, the executor or administrator of your estate will be able to fill out a claim on your behalf. The executor of an estate is the person named in the will to distribute the estate. The administrator of the estate is the term when there is no will. Dying without a will is something lawyers call dying intestate, and any of your intestate successors can apply to be the administrator of your estate. The eligible people include your spouse, your children, your parents, your siblings and their children, your grandparents and their children, and if you are a member of a First Nation who signed a treaty, your First Nation. As you can see, this covers a lot of people. And if more than one of them thinks they should be the administrator instead and contests administration of the estate, this can turn into a lengthy process. We recommend two things. One, if you're able, make a will. Our Lived Law series includes a video outlining how to make a valid will in British Columbia, and that can really smooth out the process and make this easier on everyone. Two, if you're able, consider talking to your future executor about your day school experience. This isn't necessary, of course, and students' experiences can be private and deeply traumatic. But sharing those experiences can help your relatives make a strong application for the money that you deserve. The executor or administrator of your estate has to wait to submit a claim until they have either completed the probate process, which is what it's called if you have a will, or gotten a grant of letters of administration, what it's called if you don't have a will. With those documents in hand, they can then fill out a claim on your behalf. The executor or administrator of an estate can submit a claim for that estate as long as the person is an eligible class member who passed away on or after July 13, 2007. If they need help, they can come to the ICLC, where we guide clients through every step of the application process. Now, if you have already made a claim, be that for 60 scoop or for day schools, but you believe that you will pass away before the payment is issued, here is what your family will need to do to receive that money. If a check has already been issued, such as the 60 scoop interim payments released last summer, the executor or administrator of the estate can contact the claims administrator, for 60 scoop that's Collectiva, and submit the court documents that name them the executor or administrator. They can then get the payment reissued to the estate of name instead of simply name. If they go to a bank, the bank can open what is known as an estate account, which will allow them to cash the check. Your family members will not be able to access that money until they have gone through the probate process or been granted letters of administration. Again, leaving a will speed up this process. If a check has not been issued, but the claim has been submitted, the executor or administrator should contact the claims administrator and submit their documentation so that the check can be made out in the estate of name. To summarize, if you have been involved in or are eligible for an Indigenous class action, but believe that you will pass away before you can make a claim or before you receive your payment, leaving a will can help your family members access payments or submit claims easier. Payments cannot be accessed nor claims made until your family has gone through the probate process in the case of a will or gotten a grant of letters of administration. These can take time, but we're here to help. You or your loved ones can reach out to the ICLC for help with the estate process and with Indigenous class actions. Thank you very much for watching and have a great day.
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.